is less than 25% of its proportion in the population. Educational. Castes and communities whose literacy rate is at least 8% less than the state or district average. Castes and communities of which the proportion of matriculates is at least 20% less than the state, and of which the proportion of graduates is at least 20% less than the state. Economic criteria. To be a socially and educationally backward class, you have to fulfill the following economic criteria. Castes and communities, a significant proportion of whose members reside only in kacha houses. Castes and communities, the share of whose members in number of cases and in extent of agricultural land surrendered under the Agricultural Land Ceiling Act of the state is nil or significantly low. Castes and communities, the share of whose members in state government posts and services of Group A and B, classes 1 and 2, is not equal to the population equivalent proportion of the caste or community. So any caste or any community, any group of people that fulfills these criteria are entitled to be a socially and educationally backward class, which is why, sir, this Honorable Court very rightly recommended that transgenders be included as an OBC community. Transgenders. The National Commission of Backward Classes has recommended that orphans be included in the list of OBCs. So this category, created by the founding fathers of our Constitution, has yielded the desired result. It has become the main category uniting the common people of this country across religion and across caste, across region, across geography, as backward classes, fighting for greater representation and a greater share of voice in this country. And as I mentioned last time, sir, every Varna is represented, every religion is represented, every Muslim in Kerala belongs to the backward classes because they really suffer from deprivation. So the first point I want to make very simply, sir, is to rebut this idea that this reservation for communities that fulfill these criteria is being repeatedly vilified as casteist reservation. What is the basis, sir? A caste is entitled to be a class, but casteist mindsets see a class only as a caste because they cannot see anything else, sir, other than a caste when they look. So therefore, I think we must recognize the value of creating a uniting category that cuts across various kinds of deprivation, and we must strengthen it. Now, is that being abused? Yes. What is not abused? And that's why the National Commission for Backward Classes rejected that Jat should be made backward classes. And the government, for political reasons, then government went ahead and gave them OBC category. So these mechanisms are working, sir. And I'm the first to say that these criteria must be strictly applied for the objective of giving voice and representation to people who are living in this condition. And they must be reviewed, monitored, and people who are not in these conditions, which frankly bring tears to my eyes, sir, when I read these conditions. We are talking of actual people, that they should have voice and a share. Otherwise, what is the purpose of our having freedom and democracy, sir? But it should be monitored, and it is not. But we should not throw the baby out with the bathwater, sir. That is my first point. Second, very briefly, sir, is this relationship between weakness and backwardness. I want to rebut the idea, sir, that weakness and backwardness are totally opposed to each other. When I saw the three-circle formula that Honorable Justice Butt put forward, what appealed to me was that there was a continuum running across that circle, and that was weakness. Weakness. The word weakness comes from the Proto-German word Weiku, W-A-I-K-U. It means soft. It will yield. No capacity to resist. So if you take Justice Butt's circle, as he said, at the center you have the greatest weakness of SC and ST. Then you radiate out and the weakness is less. The capacity to resist improves. And at the outer end, I would say there's massive human suffering in these groups, and to call them homogeneous because they're assumed to be caste does not do justice to that category, sir. So I think we must understand that weakness is a quality, sir. It's a quality of yielding, being soft. Backwardness is a rank. Are you towards the back or are you towards the front? Weakness produces that rank, but you can't, they're not intended to be opposed to each other. You cannot use backwardness to fight weakness or weakness to fight backwardness because they're two categories. And I saw in these three circles, sir, a rank and a recognition of weakness as I saw it myself. And I thought that was quite very helpful. Lastly, sir, my rebuttal point is, please don't divide the joint family constitutional joint family of social, economic, and political. Sir. They go together. The rest of the world has just begun to realize that what is social is economic, what is economic is political, what is political is social and economic. They're all different sides of a complex human condition. And so we have moved away, sir, from, in the last 70 years, from measuring poverty simply by looking at consumption and the right to buy food, to multidimensional poverty indicators, where we are looking at various aspects. And we find, sir, that poverty is defined as a multidimensional problem. No less than the IMF said, sir, that it's a multidimensional problem that goes beyond economics to include, among other things, social, political, and cultural issues. This is a recognition that we had in 1950s in our constitution, always speaking of justice, social, economic, and political. And to achieve justice, social, and political, economic, you cannot just look at economic criteria. So separate from Indira Sawhney, sir. Indira Sawhney expressed the right sentiment. Now, if today you were to offer me the proposition that reservation should be on social criteria alone, I would be the first to oppose it, sir. I will say, don't ignore the economic criteria. Don't ignore the political criteria. If you say reservation should be only on political criteria, I will be the first to oppose it. I'm not against economic criteria, but I'm against single point criteria to determine human suffering and human backwardness. Poverty remains an extremely complex morbidity to recognize. But if we have made any progress, it is to realize the complexity, not to reduce it to 8 acres of land or X amount in the bank. So we've left that behind, and I think India will be shamed in the rest of the world if we still show that that is our approach to understanding human suffering, sir. So these are my 3 rebuttals, sir. Very quickly, I'm aware of the time. Now I want to move to 3 basic structure violations, sir. We've all focused, and my learned colleagues who are far more able than me and far more knowledgeable than me have very deeply pointed out to many basic structures, although the respondent side has tried to narrow us to only two issues of whether or not the economic criteria can be is valid under the constitution, whether there's 50% reservation. But actually, number of submissions have been made on basic structure. But many of these submissions have focused on the exclusion. I want to focus on the inclusion, sir. My real problem is with the inclusion, not with the exclusion. And what is my problem with the inclusion, sir? My problem with the inclusion is that for the first time in our history, being a member of a forward class, socially and educationally forward class, has been made a prerequisite for getting government assistance. If I'm a member of a born as a member of a socially educationally backward class, sir, how do I become a member of a socially and educationally forward class? Never before, sir, in the history of this country, has there been a requirement that to get government assistance, you have to be a member of a socially and educationally forward class. You have to be socially and educationally forward. This is why I think, until recently, the idea was to tackle financial weaknesses. Yes, there are genuine cases of financial weaknesses. I myself know one person, sir, who's a member of the royal family of a state, and he was telling me how he grew up in utter poverty, had to eat roots when he was a child. And I told him, I said, yes, you had to do that, and you should never have had to do that. Your suffering is no less or no different than any other child in this country. But you must remember that no door was closed to you by society. No door was closed to you. I know someone else who was very poor from a priestly family, because the father and the grandfather decided that they want to serve the temple and be priests and live in that condition. But when the children decided, no, we will study, sir, every door opened for them, sir. Every door opened for them. In school, in college, outside the country, in the best jobs of the country, and my friends, both of them ended up in top positions in the country. So our problem is with doors being closed by society on us. And that is a problem that can be solved only by forcing those doors to open through a reservation, a set aside such as reservation. Now let me turn to, so my first problem is that this requirement violates the basic structure. And I will come to that in the methodology in more detail, but that's the first. I'm only submitting that 3 things violate the basic structure. One is this prerequisite that you must belong to a forward class to get EWS is a violation of the basic structure, number 1. Number 2, sir, there is a requirement sorry, sir, I'll just take 1 second. Yes, sir. The second difficulty with the violation of the basic structure is that is about the way 103 amendment treats reservations. Now, I believe reservation is a very dangerous instrument, sir. It's a very dangerous instrument. Because it necessarily involves displacement and discrimination. You're pushing someone out to get a chair, which is why we are before you, sir. Because the question is that being done fairly and justly or not? Now, because reservation is a very dangerous instrument, Dr. Ambedkar himself in the Constituent Assembly said, don't apply it to more than 50%. Not because he wanted that to be a rigid criterion to be used to destroy the social and educationally backward classes and the SC/ST, as some of my colleagues may wish to do. But because he realized the danger of reservations, and he wanted more than anything else that every Indian should have equal opportunity. That's what the struggle of the movement always was. So it's a dangerous instrument. So therefore, they anchored that those reservation, put chains on it, so that it will not run out of control. The chain was that you shall be used only for representation. And you shall be used only for representation by backward, for those who are being discriminated against. That instrument, you can do anything else. You can help people in any other way. But this dangerous fellow, don't use him for anything else except to open the doors that society closed on you. You use him as a lever to open those doors and nothing else. Now, what 103 does is, sir, it destroys those harnesses on reservation. It says to uplift someone. It doesn't matter whether he suffered from discrimination or not, but to uplift someone, you can use reservation. It is reservation unbound. If this amendment is approved, in short order, sir, there will be thousands and thousands of programs in this country to give exclusive assistance to various groups of people through reservation. Reservation will be unbound and let loose on this country. So instead of tightening that and making sure that it does not apply except where the truly deserving need representation, we are doing the opposite by universalizing and compartmentalizing reservation. I agree, sir, with you that compartmentalization already exists. It's a problem, sir. Let's not make it worse. When I heard the arguments about compartmentalization, ma'am, my mind went back to 1896. I was never there, but went back to the Supreme Court of the United States in 1896.
Bless you.
Where they considered a case where a law was enacted by the state of Louisiana that railway compartments, it's ironical that the other side used the word compartment, railway compartments will be reserved by race. One compartment for whites, one compartment for blacks. And if you entered a white compartment, you would be fined and prosecuted. And so some civil rights activists decided to test that law. A man who was partly white, partly black entered the compartment. He was caught, he was prosecuted. He appealed the case. The case went to the United States Supreme Court in a case called Plessy versus Ferguson, 1896. And in that case, the state argued that what I'm giving is compartments, separate but equal. Separate but equal was the defense of the state. Everyone, no, I'm not taking your share. You won't take my share. What is your complaint? You're getting your own compartment of the same quality. So the state argued separate but equal. And it was upheld by the US Supreme Court in what has today become one of two most disgraced judgments of that great court. It took until 1954, 60 years and 3 or 4 generations before it was reversed in Ward versus Brown of Education. So I was reminded of the arguments that were made in Plessy and Ferguson when we heard an argument from our union that we want separate compartments and no one should complain, just be in separate compartments. So this is a violation of the basic structure idea of unity and integrity and harmony and fraternity of this nation. Fundamental violations, sir. If an imprimatur of the Constitution of the Supreme Court is put on this argument, which has now been openly placed before you, sir, you cannot but take judicial notice of this. The Attorney General of the country has placed before the Supreme Court of the country, we want separate but equal. And It took 60 years for the United States to realize that separate but equal is nothing but separate and unequal. That's what it is in reality. And therefore, sir, compartmentalization and unleashing of reservations, reservation becomes a free agent virus running through society, compartmentalizing everyone. What is the legacy that you will leave us, sir? So these are my limited points, sir. I have about 7 minutes left on the basic structure violations. I move to the last part, sir, methodology. And on methodology, sir, I turn to Justice Kapadia's judgment, sir. Wonderful judgment, as all of you know him, a judge of great clarity and great wisdom. So if you turn to para 22 of the judgment in M. Nagaraj, so I don't have the right, I rely on Indian Qanun and all that, sir. So I don't have the right numbers, but it's para 22.
122.
Sorry? It's page 242. Yes. Yes. I'll just read the quotation, sir. The question, because my time is limited, I have only 5 more minutes, sir. The question which arises before us is regarding the nature of the standards of judicial review required to be applied in judging the validity of the constitutional amendments in the context of the doctrine of basic structure. So this is exactly on point, sir. Justice Kapadia is giving us a methodology on how to decide the validity of the constitutional amendment in the context of the doctrine of basic structure. Sir, if I would like to go through, but I may need another 4 or 5 minutes, sir, if you permit me, sir. So, sir, para 23 says the recognition of a basic structure. It's a brilliant analysis, sir. Recognition of a basic structure in the context of amendment provides an insight that there are, beyond the words of particular provisions, systematic principles underlying and connecting the provisions of the Constitution. So what is clashing with the basic structure, sir, are the principles underlying the provisions, not the provisions themselves, is what Justice Kapadia is telling us. These principles give coherence to the Constitution and make it an organic whole. These principles are part of constitutional law, even if they are not expressly stated in form of rules. Now, this is a very important and significant limitation to the idea of basic structure, sir. Justice Kapadia is saying that if you want a principle underlying a provision to be part of the basic structure, it has already got to be a part of constitutional law, recognized by courts and binding on the legislature. So that prevents anyone from coming in and putting any random principle as a part of the basic structure by just putting it into the Constitution. So you have to go through a process where there is a law, there are principles that are established by courts, accepted and are binding on the legislature. Then you say, okay, that is the principle by which I will determine the nature of the provisions. He says the provision acquires its characteristic as a feature from this underlying principle, sir. So it's like saying there's a car. A feature in the car is it has steering wheels and brakes, and it has a radio. These are all features of the car. But some features are essential, like steering wheel and brake, but the radio is not essential. So Justice Kapadia says, I won't read the whole thing, sir. Justice Kapadia says, you look at the provision, you identify the underlying principle, and then from that underlying principle, the provision gets its features. And then you see where that underlying principle fits in the larger scheme of the Constitution, its goal and its scheme, its objects and its scheme. And then see whether it is a radio or a steering in relation to that whole scheme. If it is essential, then you say it is part of the basic structure. That underlying principle is part of the basic structure. And as I said, sir, that gives us the safeguard, a great safeguard, that unless a principle first becomes part of constitutional law, it cannot even be a non-essential feature of the Constitution. It cannot even be a non-essential feature of the Constitution. In my academic work, sir, I have emphasized this, and I've regretted that this has not been developed more to prevent, this is a safeguard to prevent random principles coming in. Now, sir, I will not read, for lack of time, I will not read the rest of the passages, but I'm looking at para 22, para 23, para 25, para 28, and para 37. In 28, Justice Kapadia refers to the working test evolved by Chandrachud J in the election case, in which the learned judge has rightly enunciated with respect that for determining whether a particular feature of the Constitution is a part of its basic structure, one has perforce to examine in each individual case the place of the particular feature in the scheme of the Constitution, its object and purpose, and the consequences of its denial on the integrity of the Constitution as a fundamental instrument of the country's governance. But I think Justice Kapadia's unique contribution is to qualify that the principle must be a part of constitutional law already and must be binding on the legislature. Sir, now, finally, sir, in the last part, let us apply, sir, to apply this principle very quickly, so there's no time, to 15.6 or 16.6. What is the underlying principle of 15.6 and 16.6, sir? The underlying principle is that those who are poor and are socially and educationally forward and therefore deprived of reservation must get reservation. This is the underlying principle. Now, this underlying principle is not an established principle in constitutional law. It is not binding on the legislature. And it is in violent conflict with principles of equality, with the features of the Constitution that already exist to advance its objectives, which have been recognized. I have a list of, I don't have time, but I can go through the cases and the specific basic structure principles they establish. Many of them are in Keshwan Bharati. All of you know that more than I do, so I don't wish to take time on that. If you wish, I can. So therefore, sir, if you apply this principle to this test, you easily come to the conclusion that these three provisions, compartmentalism, the forwardness as a precondition, the quality of forwardness as a precondition to get government assistance. So this can be extended as a general principle to all aspects of life, sir, not just restricted to reservation. And the letting loose reservation in this society without any restriction as a benign welfare activity, like a loan mela, right? Just go and give it. These three specific parts of 15.6 and 16.6, I think, very violently oppose the conflict with the basic structure. Last part, sir. Last part. What's the way forward, sir? What's the way forward? Looking at it from the point of view of the court, I think there are two ways forward, sir. Three ways forward. One is to strike it down. The other is to sustain it as it is. But I think there's a third way forward, sir, which does not involve reading down, does not involve severance, and can solve these by basic structure conflicts in one stroke, sir. What is that, sir? And that is to take now. So this amendment is before you in two versions, sir. Now, after these 2 weeks of discussion, it's there in two versions. One version I will call the constitutionalist version, sir. The constitutionalist version. The other version I'll call the forward class version, sir. So the forward class version. Now, I'll take two parts of 15.6, 16.6 and see how it is interpreted in these two versions, sir. You take the phrase economically weaker section. In the forward class version, it is interpreted as socially and educationally forward classes with a creamy layer exclusion and other than 15.4, 16.4 classes. But in the constitutionalist version, sir, you can read economically weaker sections because of its reference to economic weakness, not financial weakness, and to poverty. The entire justification of the union has been premised on poverty alleviation, sir. And poverty alleviation, as I said earlier, is a much broader context than financial incapacity. You can read it as below poverty line, BPL, with priority to the neediest, irrespective of caste and creed, sir. Send a strong signal to this country, sir, that we've reached a stage where we recognize poverty without respect to caste and creed. This is an opportunity to do that. So the constitutionalist interpretation of this phrase would be BPL with priority to the neediest, irrespective of caste and creed. Now, the more difficult one, the second phrase, other than the classes mentioned in clauses 4 and 5. There, the forward class interpretation is, this is like a yellow star that the Nazis gave to Jews. You stick it on you, and wherever you go, you're a Jew. So if you it's a yellow star is a social identity, sir. I would argue the status of OBC and SC/ST are only relevant when you are you're claiming or getting that reservation. If you're not in the room for claiming benefits, you're a human being, sir. Not a yellow star. You're a human being. If I'm an OBC in one state, there is a particular community, I don't wish to name it, it's scheduled caste in Karnataka, it is OBC in Maharashtra. Now, does that person change, sir, morph from OBC into SC/ST when he crosses the border? No, he's just a human being. But his entitlements and claims may change. So socially and educationally forward class interpretation are converting class into caste and attaching OBC, SC, ST to all of us like a caste that stays with you. They cannot see us as human beings anymore except as OBC. So we reject that approach, sir, and take a constitutionalist approach. What is that constitutional approach, sir? It is, we see this other than the classes mentioned in clause 4 and 5 as meaning that the eligibility criteria for forming the sections in Articles 15.6 and 16.6 shall be other than the eligibility criteria for forming the classes in Articles 15.4, 15.5 and 16.4. For example, in 16.4, 16.5, you have to be backward. So you cannot use that eligibility criteria in 15.6, 16.6. You can use poverty. You can use poverty. So other than, sorry. Sir, the Constitution is always at the level of criteria, sir, not at the level of identifying human beings. All these are criteria, whether it's EWS or OBC, SC, ST. The Constitution sets out criteria, broad criteria. So why are we reading the Constitution as referring to people and putting a yellow star on them? And why don't we refer to this as criteria? Now the question is, sir, last question is, this will not, as the bench had observed.
So what are you saying?
Yes.
That other than means descriptively.
Other than refers to the criteria, not to the people. The criteria shall be other than.
Criteria means it has to be descriptive. See, criteria, we can call it, it's a matter of semantics.
Yes.
Other than means you have 4 socially and educationally backward.
Yes.
Now, other than can mean 2 things. The way we have understood so far is exclusionary.
Yes.
The other way to read, perhaps, is that this is descriptive. In addition to,
Yes.
in addition to the category in 4, we have this category.
What has been described in 4 and 5.
What is described? In addition to that, we have this. Therefore, in that event, there is no exclusion.
Yes.
Then you have you can call it a silo, you can call it a separate container, where everybody competes on the basis of poverty.
No, sir, as you can read it in any manner.
You are rendering the entire observation.
That is not a manner that is referring to human beings. Human beings. So, for example, criteria for sports persons is different from criteria for persons with disabilities. So, if you want to get horizontal reservations under either, you can be a scheduled caste woman who's a sports person and is disabled, and you have to deal with 4 sets of criteria. And there is nothing in interlocking reservation that says you cannot have multiple eligibility. So
what Justice Jeevan Reddy said, interlocking
reservations. So what I'm saying, sir, is that we read these as we ensure that there is no overlap. Now we can attribute certain rationality in saying that backward classes and weaker sections are very closely interrelated. They're 2 sides of the same coin. Therefore, all the more reason to ensure that the eligibility criteria are distinct and with intelligible differential. So here, for example, no need to put this criteria on what your stigma is or your social status is. You can just concentrate on the deprivation. This MPI, so the multi-dimensional poverty index criteria. You can do that, and yeah. Sorry, sir, sir, forgive me, sir. The last point I want to say, sir, is that, yes, this may mean that the political intention of providing a separate compartment for a particular group may not be achieved, but that is not the concern, sir, of a court. And, that will never be the concern of a court. First, this will not be the first time that a political intent has been frustrated by what Justice K.K. Matthew, I forget the judgment, beautifully once called the need for all constitutional provisions to be in fraternity with each other. So when this, whatever the political intent may have been, once 16.6 and 15.6 enters the house of the Constitution, it acquires all the characteristics of all its friends in the Constitution, sir. 21, 19, 14, 16. They're all one big friendly family, sir. And they have to live in harmony together. And so this interpretation, where we say that other than means that the criteria shall be distinct, eligibility criteria shall be distinct to avoid an overlap, will allow you, sir, to keep this going without running into the letting reservation, run loose, disconnecting reservation from backwardness or poverty, and without
that process. They are disrupting the harmony. This entire process is you in the alternative suggested way forward. It's required to be, maybe it's taken up only when if we come to a conclusion that these amendments, 103rd amendment, whatever is provided is not otherwise living in harmony with the other provisions of equality wherever they are. If they are, otherwise they could exist in harmony, they could exist.
Of course. But it all depends on what interpretation we give it, sir. These are not provisions which are neutral. So as I said, there are two interpretations you can give it. One interpretation will allow them to live in harmony, sir. But another interpretation will not. There's no doubt about it, sir. Thank you so much, sir.
With my lord permission, I am seeking only 30 seconds, my lord. I will
Deeply
point out only
grateful to you.
two things, my lord, 30 seconds, not more than 30.
Your data.
Yes, my lord.
We have seen that.
Yes, my lord. I want to point out on two things, my lord. I want to point out on data. In Jammu Kashmir, 34% OBC people and 2% reservation in Jammu Kashmir on the OBC category. And that matter pending before the alternate bench in item 105, my lord. And state of Madhya Pradesh, SC, ST, OBC people are 89%. And OBC people, admittedly, 52% population in OBC category. And reservation only 14%. And my lord, the ratio is a very important one. I want to read only one paragraph, my lord. This define the
Get into that issue, that whether the ratio-wise or proportionate representation.
Yes.
What are you hinting at, sir?
So, my lord, these people are not adequately represented in the government sector in anywhere, my lord. That's the reason we want to point out.
According to you, supposing, for instance, in a given state, scheduled tribes are more than what is the percentage of reservation meant for them. This is what you are hinting?
My lord, I want to point out this, my lord. In 52% population in Madhya Pradesh, only 13% people are working in the government and PSU, my lord. So this is the actual situation in the ground level. And they are in 20% reservation given. And
Sir, what we are focusing on, and again you would request, sir, how this particular way of looking at the thing would help us in arriving at a conclusion whether this amendment will disturb the basic structure or it disturb the basic features or not. Individual cases or individual layout or spread of the persons or the percentage of persons getting into employment, not getting into employment, maybe because of variety of factors, sir.
yes, I want to just point out, reservation is the tool to give an adequate representation all corner of the society.
And that what you are now trying to say is that there is inadequate representation for certain sections of the society.
Yes.
Understood. But that is not something that we are called upon to decide. We are called upon to decide completely different dimension of the problem. So we can't by our decision make some kind of, adequate representation for those who are inadequately represented. What we are called upon to decide is what is the reservation, what is the content, whether it violates basic structure or not. Correct? Your data is not going to help us in that direction.
Only one thing, my lord. If this amendment is upheld, then again, my lord, we are excluded in this amendment. OBC SC is not included. So we are excluded in 10%
Council
reservation.
have argued well.
I'm sorry.
So please rest.
I want to just point out, we are already placed the data, my lord, so kindly.
That's all right, sir. You have told us at least 4 times.
I'm sorry, my lord.
Yes, we have understood.
I'll take 20 seconds, Lord Sir, just to apprise that the criteria of 8 lakh limit is pending before court number 2. So
That's all
in case Lordship is going to upheld or whichever way, it should not be decided on the 8 lakh limit.
Okay.
Here, file the IA, that is no reason.
Well, in this matter, your lordship made a beginning with advanced written submission.
Mr. Sharan, we
Timeline.
want your again assistance on the point because by the time we have come to the close of this particular matter, we started with say 1 unit, today we are 20 units, correct? We want you to again put that in concise form. If you and Mr. Kanu Agarwal, if you can, actually, we can bank on your services. Please do that in next 3 or 4 days.
Because we'll do it in the next 3, 4 days. Just one suggestion I had, from the experience we have gained here. Because your lordships may consider advanced timelines and advanced written submission as a part of practice directions for constitution bench matters generally. Because the bar is also learning. Because in this matter, you are learning.
No, it should be not just constitution bench matters, every 3 judge bench matters.
Because the beginning can be made because we are also learning, because your lordships, so despite the advanced, we were still submitting.
Your lordships, the notes that learned AG and SG and submit, your lordships will give us till Friday to put it to the.
What? We
The
couldn't
notes,
gather.
your lordships, because now there's a flood of material which is coming.
Okay, very well.
By Friday, we'll submit our notes.
What next?
Now, please, no more.
Submitted your notes.
No more.
Because your lordships, there's a new. flood
That's
of
all right, that's
information
all
which
right.
has come.
But it's okay. You are appearing for some interveners now. To what extent do we keep on
No,
entertaining?
your lordships, the learned AG and learned SG also.
Maybe so.
Yes, your lordship. So we'll submit it by Friday as well.
Please don't do that. Please don't do that.
Lordships, because
We don't want to be confronted with new points.
there
Let's be
won't
very
be
clear. So
points.
we are sealing everything now, except where it specifically permitted.
It's only
That's
for,
all. No,
yes,
I
it's
don't-
only for lordships assistance if lordships wants it in
Please
a
let it be
proper
so.
fashion.
That's unfair because if you come up
We
with
have
some
given you
points,
sufficient
rebuttal,
time to make your
There's
own.
no I'm just submitting, there'll be no new information. We are going to just
But
put
then
it in a
if
manner.
it is not in you, please leave it to us. We will
Very well,
take care.
as your lordship desires.
Grateful.
Thank you. We'll come back in 5 minutes, sir.
Right, ma'am.
of the 68 order, total exclusive jurisdiction of the Election Commission of India. So kindly see 15, my lord, which I just complete and then go straight to the 10th schedule. The commission may, after taking into account all the available facts and the circumstances of the case and hearing such representatives of the sections or groups and other persons that desire to be heard, kindly mark the next word, my lord. Decide. So for the purposes of 21A, political party, there is a question mark, the decision has to come from here, not from the office order. Decide.
The issue is not so much whether the election commission has the power or not. What they argue is the batting order, which should be decided first. But the question is, would that arise in a context where the channels are completely different and the process and the method and authorities are all different? But are there any cases where the issue relating to anti-defection as well as matters relating to party determination have been commonly taken up, not episodically, but at the same time?
My lord, I'll just check up, I'll confirm it, but I'll come back to your lordship. My lord, please permit me, I have understood, my lord, I'll see you. My lord, I'm coming to your lordships are putting it. I'm sorry.
Yes.
Lord, your lordships are putting it to me that in which order these two issues to be decided, because let us assume that the two issues does arise, that who is the leader of the party and whether that incident of disqualification has taken place or not. If these two issues are to be decided, it must be decided first. That's what your lordships are wanting to know. My lord, my respectful submission is this. I will need go to straight away to 1A and to 1B of the 10th schedule in a moment. My lord, what I was reading here is the decision who is the political party, who is the leadership, who has to give direction on behalf of the party, in the name of the party. That decision can only come from 15. Okay. Now, let only see the 10th schedule. Before that, my lord, kindly come to page 8 and page 10 of this compilation 1. Because if this is the position, my lord, taken on oath before this honorable court, where the writ petitions are filed on daily basis on every event taking place, after this position is taken up by the other side before this honorable court, ground D, my lord, I want to read only 4 lines and ground next page, page 10, para 36. Then, my lord, therefore, a contradictory position by filing a writ petition would not have been agitated, and that is the reason why no writ petition, quali election commission jurisdiction or election commission proceeding is not filed.
Ground D where?
Ground D at page 8.
And this is
My lord, that pages are at the bottom. On the top, there is some page 38, but the running page of this compilation is page 8 and page 10.
This ground D, Mr. Maninder saying, this ground
Isn't the writ petition?
part of the writ petition.
Writ petition filed by them.
There are.
No, my lord, your lordship must know, my lord, that on every event taking place after the floor test, they were filing writ petition. They have taken the position in this writ petition where there is no question of jurisdiction or proceeding further of the election commission. And they have taken this position. Kindly permit me, the last 5 lines in para D. Who is the Shiv Sena? Who is the Shiv Sena? The moment this question comes, my lord, it is also our common case. Exclusive jurisdiction is of the Election Commission of India. And they said so. And once they said so, my lord, there was no occasion for them to file any substantive writ petition questioning that position, because they can't live with an inherent contradiction in their stand. Now, my lord, if that is the position, will your lordship permit an interim application to be filed in some other writ petition? Kindly see who is the Shiv Sena. That is the domain of Election Commission. Admittedly, recognition of Shiv Sena and leadership by so and so has been endorsed by the Election Commission, and there is no dispute. Now, kindly see para 36, page 10, next page. This is a part of the rejoinder, para 36. After our stand was filed to this writ petition, the file the rejoinder. So, original position is the moment question arises, who Shiv Sena? Election Commission. Kindly see 36, third line. If the delinquents were so keen on a change in party leadership, they ought to have approached the Election Commission in the first place. So why, what did I came for? I came for extension of time, which is in violation of the rule, only 2 days, and I asked for 2 weeks. 2 weeks is granted by your lordship. Compliance of natural justice. That has nothing to do with either the office of the Speaker or the Election Commission of India.
All right, Mr. Maninder. Yes.
Only 2 minutes. Kindly come to 2. Kindly come to 2, but the 10 schedule. 10 schedule. Only about 2 minutes and I am done. All judgments are cited. I have nothing for this hearing. But kindly come to 2-1. There is no political.
Mr. Maninder Singh, it is read and reread and reread.
Only 1 minute I will take. You are not.
Otherwise, we will have to hear Mr.
I will just clear it in 1 minute. 2-1A. 2-1A and 2-1B. The last word of political party and in the contrast in clause 3.2 which is deleted and clause 4.2 of the merger and the split, it's legislative party. Now in this, who is the political party and who can issue validly in law direction to the political party? Unless that question gets decided, there is no ambiguity in that regard. Speaker has no jurisdiction. And that is why the order is that once such question arises, EC will decide first. And that is their petition. Ground D and para 36 in rejoinder. Grateful, my lord, I am deeply obliged.
Yes, we did, Nani.
Very briefly, my lord, I realize the lordships are very keen to hear a detached voice rather than partisan interest. Lord. So I'll just state my proposition. Lord, my learned friends have dealt comprehensively with the distinct jurisdictions of the Speaker and the Election Commission. One decides disqualification of MLAs in the House. The EC decides intra-party disputes. However, the question of disqualification, and what instantly I hope to answer my Lord Narasimha's query. The question of disqualification under the 10th schedule is governed by a mandatory procedure. Particularly, there has to be a notice, a hearing, rules of natural justice, and a reasoned order. Although there is no concept of potential or deemed disqualification, it has to be actual, however, not a deemed fictional one. The entire case of the other side, trying to link disqualification with intra-party disputes, is based on a disqualification which has never happened. There is no such question of a deemed disqualification. That fiction is the fiction of the other side. Thirdly, allied to this question is that the deputy speaker, in this case, there was no speaker because the then speaker had resigned since 5th February 2021. But the deputy speaker in this case was disqualified from embarking upon the adjudication procedure because it had been brought to his notice that he had lost the confidence of the majority in the House for his position as deputy speaker. Now, my lord, this is not just Navam Varia's case. This is actually a mandate that when your own position as deputy speaker, i.e., the adjudicator of disqualification, is under question, then it is not just Navam Varia, they amplified it, but it's Article 181 of the Constitution's mandate. And I'm not going to read it out. Your lordship will just note that Article 181 says this, that when the speaker of the deputy speakers, a majority is itself questioned, he must desist from the adjudication process. However, it's not just Navam Varia, which is one of the questions of law propounded. Navam Varia does say so. And we're having a second look at it, but also Article 181. Then we've got two more propositions.
Yes.
Any link, in my respectful submission at the outset, the distinctive jurisdictions of the Speaker and the Election Commissioner, my lord, is determinative of this matter. That's almost conclusive. But my lord, any possible link between disqualification and the powers of the Election Commission to deal with inter-party disputes has been snapped by the very important event of the Chief Minister resigning on the 29th of July 2022. On that night he resigned. Sorry, 29th July. Sorry, June. 29th June. I'm so sorry. 29th June. Now, my lord, When that happened, the government fell. Nothing that happened thereafter, after he resigned, was a consequence of what happened previously. When the chief minister resigned, what kicked in was a process which was obligatory on the governor of the state. The governor had to then decide whether he could find a stable majority, which in turn necessitated discovering that person who commanded a majority of the house, and that person could therefore offer a stable government. That the governor proceeded to do. And because this is the mandate of Rameshwar Daya of 2007, I'll give us lots of the citation. Rameshwar Prasad. Number one, in that judgment, the court said when the governor is setting about the task, and it's paragraph 161 in particular, watch it just now. When he is setting about the task, his constitutional obligation to form a stable majority, he has not to be deterred by any questions of potential disqualification. So the governor did that, and a new government came into existence. Now, my lord, when a new government comes into existence, a stable government, one more article kicks in, and that is Article 178. Please see that.
To give the citation of Rameshwar Prasad.
Yes. 2006 to SEC page 1. The State Assembly of a state shall, as soon as may be, choose 2 members of the Assembly to be respectively Speaker and Deputy Speaker thereof, and so often as the office of Speaker or Deputy Speaker becomes vacant, the Assembly shall choose another member. Now, on the new government being formed, an election was held for a new Speaker. This was the mandate of 178. A new Speaker now has taken, and he took office after a vote. They participated in that vote and they lost. There is now a new Speaker. Any questions of disqualification? And my lord, the Deputy Speaker only performs the task of the Speaker when the Speaker is not there. Once you have a Speaker, any question of disqualification now goes to the Speaker. There is no need of disqualification, and they want to run away from the question of actual disqualification because the new Speaker has come. So, in short, my lord, I would like.
Thank you, Mr. Datta.
But just one question of justice. But there is a judgment of the division bench, a recent judgment of the division bench, which goes into this between 10th schedule and the election commission. It's a division bench of the Kerala High Court.
What is the citation?
Yes. Okay. It's in the compilation. It's 2021 4 KLT SN 33, page 51. But it's an I compilation and it's judgment number 7 in our compilation of them. Particularly paragraph 76, the last paragraph, it's the one case which decides both the issues. It's the first case I've seen where both the disqualification as well as the inter-party dispute was concerned. And the impact of each.
Mr. Solicitor, you want?
Sir, only 5 minutes because I appear for the governor, my lord. Therefore my role is different, my lord. In my role, my lord, I have already played, and if required, my lord, I may play, but only question your lordships in the today's hearing required to answer is this. But when Article 324 was framed, just giving a little background, and 5 minutes is broadly outer. When 324 was framed, so there is a beautiful discussion which I will not read, I pass it on, where Dr. Ambedkar examined what was the purpose of 320. And one of the main purpose was that certain political questions may arise as against the constitutional questions. And those political questions, there has to be an authority who, apart from conducting election, will also decide. And that is the election commission. Your lordships would also not possibly be able to go into the political thicket in case of president rule, etc., in a different fact situation which is not arising. The only question, which needs answer for the today's limited hearing is, can your lordships take a call whether this faction is right or another faction is right? That answer, will decide today's hearing. Answer in my respectful submission, no. This is essentially a political question. There are rules framed by the Election Commission of India as to how that question is to be gone into and decided. Because this is not for the first time that such a situation has arisen. That within the party, 2 factions claim that I am the original party. somebody will have to go into that question. And that somebody, under the scheme of the Constitution, is only the election. Third question, whether both would be overlapping. In other words, suppose the question of disqualification is held against the client of Mr. Paul and Maninder Singh, would it have any impact on the exercise to be undertaken by the Election Commission? The answer is no. Suppose the Election Commission takes the call that this faction is the correct faction, represents the original political party, would that have any impact on the decision to be taken by the speaker? The answer will be no, because your lordship Saras's statement, both spheres are.
Yes.
Here the speaker will decide that whether they voluntarily gave up membership, etc. They would argue that we are within the party, but within the party there is a freedom of speech and expression which we were exercising. That is for the speaker to decide. But even as disqualified MLAs, they would still continue to be members of the political party, because there is no disqualification from membership. So the Election Commission is merely deciding which group represents the original one. So, my lord, right now, for the limited purpose, my respectful submission, my lord, is that let the Election Commission discharge its duties.
Thank you, Mr. Datta. Mr. Datta?
Lord, my submission earlier are that the functioning of the Election Commission is completely different and independent from the role of the Speaker in the scope of the 10th schedule. In fact, Lordship sees the 10th schedule. The heading refers to C Articles 102 and 191. Let us first go to those articles. Lordship just takes 10th schedule. This Articles 102.2 and 191.2.
Yes.
And Lord, since we are referring to a state assembly, I will confine myself to Article 191. So, Lord, I want to show the constitutional provisions and the statutory provisions which show that the Election Commission's role under the Representation of People Act 1951 is completely independent and completely different from what happens in the 10th schedule. If your Lordship now comes to 191 of the Constitution, Lordship will note that along with the insertion of the 10th schedule by the 52nd Amendment, they also inserted Article 102.2 and 191.2. And if your Lordship sees 191.2, a person shall be disqualified from being a member of the Legislative Assembly or Legislative Council of a state if he is so disqualified under the 10th schedule. Now, please come to 191.1a. Lordship kindly sees, person shall be disqualified from being chosen